But that's the order I'm going to go in. So I'm going to start with the petitioner's motion for contempt. So, Mr. Gleckman, if you would.
Good morning, Your Honor. Adam Gleckman on behalf of Samantha Gibson. This is a very straightforward matter. You've heard hundreds and hundreds of times in similar situations. This is a straightforward petition for contempt for failure to pay child support. It is well established that a party who has failed to pay support under a court order when he has the ability to pay may be found guilty of civil or criminal contempt and incarcerated under either. Wright v. Wright, 6 weeks ago from the Georgia Court of Appeals, citing the seminal Ford case from 1998. Your Honor issued a verbal order on August 30th. The final judgment decree was entered on February 14th. Paragraph 27 of your decree directs Mr. Gibson to pay the sum of $10,690 per month commencing September 1st, 2022. Paragraph 35 of your decree requires, paragraph 38 of your decree requires him to pay the sum of $163,093 by October 20th, 2021. He has failed to perform under either. This is, as I said, straightforward. I have no information as to what Mr. Gibson's defense will be. I don't know if it will be that he has the inability to pay. If it is, the burden is on the one refusing to pay to show that he has, in good faith, exhausted all of the resources at his command, and has made a diligent and bona fide effort to comply with the decree awarding alimony or child support. Again, straightforward, the right case. I believe we have one witness. We've submitted our exhibits yesterday in a timely manner prior to 5 p.m., and I would expect our side to be approximately 5, maybe 10 minutes.
Okay. Mr. Ritter.
Thank you. Good morning, Your Honor. For the record,
Pull your microphone up.
yes. Good morning, Your Honor. For the record, my name is Tanya Richard, and I'm representing Mr. Gibson this morning. Your Honor, we believe that the particular enforcement that the petitioner is seeking is completely improper. This order was entered on February 14th, 2023. According to the Tate versus Tate case, let me give you a citation.
Please.
I certainly will, just a moment. Beautiful. Thank you. Your Honor, according to the Tate versus Tate case, which is 340 Georgia Act 361, it is a 2017 case. The non-proton on your particular order is not valid or effective because the litigant would be placed in a position of not knowing when they need to pay. There's another case that I will cite in reference to the non-proton. So based upon that, your order was entered on February 14, 2023. The first amount became due on March 1st, 2023. Of course, it's always offensive when someone stands up and says that Mr. Gibson does not pay child support, because he does. He always has, and he's always done so voluntarily. He has not paid the amount that was ordered by this court. We believe that particular amount, Your Honor, was actually an abuse of discretion, clearly erroneous. We'll get into that a little bit at the closing of this particular argument. Additionally, as the court knows, we plan to seek a motion for new trial. In that event, based on paragraph 40 of the final judgment decree, your order would then act as a temporary order. Consequently, any award that would not have been awarded at a temporary hearing should not be enforced at that time. Furthermore, paragraph 38 of the final judgment decree talks about the payment of the retroactive lump sum child support as of October 30th or 31st of 2022. The order was not entered until 2023, of course. We do have a Tate case that deals with that too. Non-proton is a problem. In this case, we believe that that particular award should be stayed. We are very willing to do a supersedious bond. The problem that we have, Your Honor, with this particular order is the fact, Your Honor, that we believe either in that motion for new trial or on appeal, it's going to be reversed and remanded. And so if the petitioner pays these amounts that are going to be reversed and remanded, then he has no ability to get his money back. Once it's been paid to the petitioner, even if it's reversed, that money's gone. He doesn't get credit for any future support. It's just not fair to the petitioner. And so we're here seeking some justice, and I understand that a lot of what was entered in the final judgment and decree, based upon my review of the Georgia law, a lot of it is not codified. There's no legal precedent for instance, ordering child support such that the mother can buy a house. That's not contemplated by the Georgia child support statute in OCGA 19-615. Also in the order, it says that she wants to pull back from working. I couldn't find anything in the code or in any precedent in the Court of Appeals or the Georgia Supreme Court that says that we want to award child support such that the mother can work less. So I think there are a lot of problems with the order based upon the way it was written, based upon the fact that it's just not based on precedent. And in fact, I think a lot of the provisions in the order are going to make new law for Georgia. For instance, the retroactive lump sum child support is not supported by any law. Yes, they